It is. Good afternoon. Welcome to Board of Adjustment. It's 1:30. We have a quorum. I'm going to call the meeting to order and make a general announcement that we're missing 2 board members today. So remember, you have to have 3 votes either way to move your case along. So if a vote on something today is 2-1, you're automatically continued to the next docket. So in light of that, I'll go ahead and call the meeting to order. Let's look at the minutes. It's the next item on the agenda. Everybody look at those?
I did. I'll make a motion, Mr. Chair. I'd like to make a motion to receive the minutes of September 4th, 2025.
Second.
Okay, we have a motion and a second. Cast your votes. All right, those are received. Next, we've got a few continuances. Cindy, you want to call those, please?
So I have item number 10, case number 16056, deferred to October 2. Item number 11, case number 15688, deferred to December 4th, 2025. And item number 12, case number 16060, deferred to October 2nd.
Now, I don't have anybody signed up to speak on any of those 3. Is there anybody who wants to address the board on those 3 continuances? Yeah. Come on up, give us your name and address. And
my name is Raina Daniels, address 5101 East Wilshire Boulevard, Oklahoma City, Oklahoma, 73120. So I am, in regards to 10660, I am actually the applicant, so I didn't request that it was deferred. I thought it was going to be September the 18th.
Well, we've got this is the one with the jurisdictional. There's a typo. So it's jurisdictional. I don't think we can hear this today at all. It has to do with open meeting, open record, and notice, and there was a typo on the notice. So it's going to have to be deferred.
But it's going to be October the 2nd officially though, right?
Oh, we're good for that? Yeah.
Okay, well, thank you so
And
much.
you need to be good with that also. You need to be good with that date also.
Does that work
I mean,
for
I
you?
have to be good with it. I don't have any other
No, we
choice.
No, we
can
can
move it
change
to
that.
another day.
No, I don't want it to go further than that. I mean, that was far enough, so, yeah, thank you.
Okay. All right. Now are we ready for a motion on those 3?
I'll make a motion to approve the continuance requests as read.
Okay, we have a motion and a second. Cast your votes. Those 3 are deferred. Do we have any requests for continuance deferral from anyone in the audience? We don't have a consent docket, so will you call number one?
Okay, we have
please?
item number 1, case number 16059 is a request of Wallace Design Collective PC on behalf of the City of Oklahoma City for a variance to the front and side yard setback requirements in the DBD Downtown Business District located at 125 West Reno Avenue. And this was presented to the Downtown Design Commission today, and it was approved, vote of 3-0 for a recommendation of approval.
Good afternoon, Purvi Patel with Wallace Design Collective. The address is 410 North Walnut. As Cindy mentioned, we did present this project to the Downtown Design District this morning. They had 3 members present as well, so 3 might be a lucky number today. We are requesting a variance to section 59.720, specifically the table that lists that any properties or any development within downtown are required to have no more than a 10-foot setback from the right-of-way line. This is obviously a unique project in downtown Oklahoma City. It's the new Oklahoma City Arena, and we are requesting the variance to the front and side setback. The functional demands of the arena differ significantly from what we normally see within the downtown area with the commercial and mixed-use developments. And due to the occupancy load, security protocols, and event-driven access control, the arena requires a significantly large gathering space outside of the arena itself. These are for safety issues as well, just to accommodate large crowds, to avoid pushing the public onto the street right-of-ways. So adhering to the 10-foot max setback would severely limit the design as well as create a safety concern for the site. So we are requesting a variance to those front and side yards. There's 2 variances here. One's for, it's presented as one, but one's for the actual structure itself, which is the arena, and a parking garage. The code doesn't differentiate between different buildings, so you could have a building in between, but you would still have to maintain the 10-foot setback. So although the parking garage is on the east side of the development, we still have to request the variances for that as well. So the variances we're requesting for the arena itself is 171 feet from Sheridan, 152 feet from Reno, 281 feet from Gaylord, and 201 feet from Ron Norick. And the reason for these really large setbacks is the design of the arena itself. It's a circular building. And so to meet those, make sure the curvature of the building doesn't go into the setbacks, we had to go draw a box within the interior of the building design itself. The parking garage, we are requesting 158 feet from Sheridan, 136 feet from Reno, 44 feet from Gaylord, and 692 feet from Ron Norick. Again, that's just because it's so far set back from Ron Norick itself. We do anticipate future variances, at least one for the signage, and we'll be back in front of the board for that, but the setbacks variance is one of the first ones that we'd like to obtain just in order to continue the design of the structure itself and the site. I'm happy to answer any questions you may have.
Nobody signed up on this one. Does anybody want to address the board on this application? Okay.
It makes sense to me. Probably the only thing in addition to the concerns about the functionality of the space and the security concerns, is just that it would flat look ugly, and there was a lot of time spent on this to look as good as it does. So I'm in support.
Yeah.
Appreciate that.
Okay. I think we're ready for a motion then.
I'll make a motion to approve case number 16059 on the basis that it meets the statutory requirement for the said variances.
Second.
Okay, we have a motion and a second. Cast your votes.
Thank you.
Now you're approved.
Sorry.
Item number 2, case number 16053 is an application by Lana Evans of F5 Investments LLC to allow home sharing, 9909 Larkspur Lane.
Good afternoon. I'm Kevin Sutter, representing F5 Investments.
You'll give us your address and tell us a little bit about the application?
Okay, my home address, 2713 Southwest 111th, Oklahoma City, Oklahoma, 73170.
Okay, just Well, anyone sign up to speak on this one?
Nobody signed up on this one. Does anyone want to address the board on this application? Yep, okay.
So I'd just like to go through the application just a little bit. This is a duplex.
Yes, sir.
Do you own both sides?
Yes, the entire building, yes.
It's-
We have a long-term renter on the south side currently, that single lady.
Yep. Three bedroom, 2 bath.
3-bedroom, 2-bath, 2 garages, 2-car garage. There's room to park, 4 in the driveway, 2 in the garage.
Okay, so just maximum number of guests you're requesting are 6.
Yes,
I'd like to make an adjustment to quiet hours to make them 9 p.m. to 8 a.m.
yes, sir.
On the vehicles, a maximum number of vehicles, I'll say 2 in the drive, 2 in the garage. 4
Okay.
is probably plenty. And the term would be for 1 year.
Okay, understood.
Ready for a motion?
I will make a motion to approve case number 16053 on the basis that it meets the statutory requirement for a special exception.
Second?
Okay, we have a motion and a second. Cast your votes. That one's approved.
Item number 3, case number 16054 is an application by Lana Evans of FI Investments LLC to allow home sharing located at 1804 Northwest 11th.
Name and address again.
Okay, Kevin Sutter, 2713 Southwest 111th, Oklahoma City, Oklahoma, 73170. This is a single-family home. There is no garage, but the driveway has been widened to a 2-car drive. It'll support about 6 vehicles in off-street parking.
Anyone sign up to speak on
Nobody signed up on this one. Is anyone wanting to address the board on this application?
this? Okay. Just to go over the application, the maximum number of guests you were requesting was 4.
Correct.
I'd like to add quiet hours from 9 p.m. to 8 a.m.
Yes, sir.
Maximum number of vehicles to be 4 and no on-street parking.
Okay,
And the term would be 1 year.
okay.
Ready for a motion? I'm good.
Okay, with that, I will make a motion to approve case number 16054 on the basis that it meets the statutory requirement for a special exception.
Second?
Okay, we have a motion and a second. Cast your votes. You're approved.
Item number 4, case number 16055 is an application by Lana Evans of FI Investments LLC to allow home sharing located at 1628 Southwest 90th.
My name's Kevin Sutter, 2713 Southwest 111th, Oklahoma City, Oklahoma, 73170. This is a single-family home, 2-car garage. It'll accommodate 2 cars in the driveway, 2 in the garage, 2 baths, 2 full baths, 3 bedroom. We're only requesting, I believe, 4 guests. It's a 3-bedroom home.
Nobody signed up to speak on this one. Does anyone want to address the board on this application? Okay.
And just to go over the application, maximum number of guests would be 4. I want to add the quiet hours from 9 p.m. to 8 a.m.
Yes, sir.
Maximum number of vehicles would be 2 in the drive and 2 in the garage, and the term would be 1 year.
Okay. Would the board consider a 3-year term next year?
So, yes, we would.
Okay.
That's what I was say. The first year is always just 1 year. It's kind of a trial period, make sure that the neighbors are
I will say that your fee adjustment you recently had was quite significant, to $1,100 apiece. So
Yeah.
I understand it goes to $750 the second year if we turn it in early. Is that correct? Mm-hmm. Okay, thank you.
Okay. Nobody signed up on this one either.
Okay.
Does anyone want to address the board? Nope. Ready for a motion?
I will make a motion to approve case number 16055 on the basis that it meets the statutory requirement for a special exception.
Second?
Motion and a second. Cast your votes. You're approved.
Thank you.
Item number 5, case number 16057 is an application by Alex Flores to allow home sharing located at 2515 Von Schill Avenue.
Good afternoon. I am here to represent for a home sharing. The address is 2515 North Von Schill Avenue, Oklahoma City.
Nobody signed up to speak. Does anyone want to address the board on this application? Okay.
So just to go over the application a little bit, this is a 2-bedroom home?
2 bedrooms, one
one
parking
bath.
with carport, and 1 car and 2 cars driveway.
Okay. You're requesting 6 guests. So I was wondering how you could get to 6 guests with 2 bedrooms?
Oh, they say 6? I remember before. 6? No, it's just 4.
Okay.
Sorry.
Nope, that is just fine. I want to add quiet hours to it from 9 p.m. to 8 a.m. And then on the vehicles, I wanted to just put a maximum of 2 cars in the drive
Yes.
and no on-street parking.
It's a carport too.
Okay. And then a term of 1 year.
Yes.
I'm okay. Ready for a motion? Nobody signed up.
I'd like to make a motion to approve case number 16057 on the basis that it meets the statutory requirement for a special exception. I want to say that the maximum number of guests will be 4.
Yes.
The application was said 6, and so just make sure that change got made.
Second?
Okay, we have a motion and a second. Cast your votes. You're approved.
Okay, thank you.
Item number 6, case number 16061 is an application by Jeff Cooper of Just Like Home Rentals to allow home sharing located at 810 Northeast 50th Street.
Good afternoon, everyone. My name is Jeff, and I'm here on behalf of Just Like Home Rentals today, submitting on-time or timely renewal application for a special exception, requesting or looking for a 3-year term.
Nobody signed up to speak on this one. Does anyone want to address the board on this application? Okay, nothing.
And on the application, I want to just state that it says a maximum of 10 guests on this 4-bedroom home,
Yes, sir.
and that's a continuance of the original application.
Yes, sir.
Quiet hours are I'd like to make an adjustment. I've been changing all that to 9 p.m. to 8 a.m. That's
Okay.
all right with you?
Okay, yes, sir.
Maximum number of vehicles would be 6 with no on-street parking and the term of 3 years.
Yes, sir.
Ready for a motion?
And before you make a motion, I just want to state that I do own property next to this property, but just for the record.
Okay.
Does that influence your ability to make a decision?
No, ma'am.
With that, I'll make a motion to approve case number 16061 on the basis that it meets the statutory requirement for the said special exception.
Second?
Okay, we have a motion and a second. Cast your votes. You're approved.
Thank you very much, guys. Thank you. Good to see you.
Item number 7, case number 16062 is an application KZ Enterprises LLC to allow home sharing at 1301 North Independence Avenue.
Hello, my name is Zach Regal. Not done this before, so sorry if I use the wrong words. Here for KZ Enterprises. My home address is 1204 Rockwood Drive in Edmond. My wife and I own 1301 North Independence Avenue across from the fairgrounds, looking to get a short-term rental permit. I believe he said for 1 year would be the first term there.
Nobody signed up to speak. on this one. Is there anyone who wants to address the board on this application? Okay.
So just to go over the application, it's a two-bedroom home?
Yes, sir.
One bath?
Yes, sir.
And you're asking for 6 guests maximum?
Yes, sir.
So can you tell me how you can sleep 6?
King bed in one room, twin beds in the other, and then a queen pull-out couch.
Okay, for me, on the first application like this, I'd like to go 2 per bedroom, and I'll give you 1 for the pull-out couch, so a maximum of 5.
Okay. We came up with that number because we figure a lot of folks are traveling for the fair, and it's a lot of like 4-H and agricultural families have bigger families, so we tried to pull a number that would accommodate normal size farm family, for lack of a better term.
And that's understood. This being the first time in the application, it's just something that I try to do is just the 2 plus 1. I want to make an adjustment to your quiet hours to 9 p.m. to 8 a.m.
Okay.
And then on the number of vehicles to park, I'm going to say a maximum of 3 vehicles in the drive and no on-street parking. And then your term would be for 1 year.
Sounds good.
Good with all of that? Okay.
Okay.
Ready?
I think we're ready for a motion.
I would like to make a motion to approve case number 16062 on the basis that it meets the statutory requirement for a special exception.
Second?
Okay, you got a motion and a second. Cast your votes. You're approved.
Thank y'all.
Item number 8, case number 16063 is an application by Caitlin Sonato to allow home sharing located at 5807 Hefner Village Circle.
Hello, my name is Caitlin Sonato. Address is 11405 Wallace Avenue, Oklahoma City, 73162. And I am here to renew my special exception on behalf of my address in Hefner Village Circle. It is a 3-bedroom, 2-bath townhome. I currently have it at 7 max guests. That is because I allow 2 guests per bedroom with 1 sleeper sofa. And there is a 2-car garage and then room for 2 cars in the driveway. No street parking, but we do have additional parking down the road as needed.
Got folks signed up on this one.
We should hear from them.
All right. Mary Irvin.
Hello, board. I'm Mary Irvin. I live at 5826 Hefner Village Circle, Oklahoma City, 73162. I'm the president of the Hefner Village Homeowners Association. I've been the president for 2 years, on the board for longer than that, and a very involved community person in our community. Hefner Village is a community of 236 townhomes of a close-knit group. We were established in 1974. Our covenants and restrictions were written at that time by the developers, and in section 8.1 of our covenant, it states no gainful occupation, profession, business, trade, or other non-residential activity shall be conducted on any lot or in any residence or on any lot or in any residence or detached structure located thereon. I feel like, and the rest of our community, that is against Airbnbs being in our neighborhood for various reasons. Don't have anything against Caitlin. She has run an Airbnb in our neighborhood for over a year, and that is without license. We have been working diligently with our attorney for the last 2 years trying to get this stopped in our neighborhood. It's not something we want. Our covenants state no businesses. They are issued a business license, and that in itself, I believe, is an admittance that this is a business. It's not specific in our C&Rs, Airbnbs, Verbos, short-term rentals. At the time that they were written, they thought businesses would cover hair salons, saloons, dog cutting businesses, etc. We cannot list every single thing in our covenants. It's very expensive and time-consuming for us to get 268% of 236 residents to vote nowadays. It's very hard. We really would appreciate your consideration that our covenants do say no businesses, and we feel like getting a business license, that this is a business. We just can't list every business singly. If we must, we will, but we really would like your consideration in this. We have not been here to talk to you about previous situations, and we thought just sending our paperwork in was fine. That's what our attorney told us. But this time I wanted to come and just say, hey, you know, we're throwing ourselves on your mercy. I have one across the street, and it's not fun. And a lot of times it's fine. But it's not something that is allowed by our covenants, and it puts us in a direct confrontation with the city. I believe that we can say that on our covenants. But we really would love for you guys to rule in our favor to stop this license from being given at this time.
Questions, comments for?
Any questions?
Yeah,
I'll
I'll
be
just
glad to
ask
answer
questions.
questions. We also, may I add, we notified Airbnb and Vrbo short-term rentals on May the 1st, 2025. We did not notify them after that. We sent out a letter, then we sent out a certified letter. Caitlin Sonoto did not claim hers at the post office. We waited another 10 days. We turned it into our attorney, who then wrote a letter to her, and that's when she got an attorney, and that's, I mean, it's gone to this now. But we did give them plenty of notice. We've been nice to them and kind and asked nicely. We understand they may have at one time been our neighbors, but this is something the community doesn't really want, nor is it in our covenants to have.
And I totally understand that. I was just going to say, in your statement, you said that they were operating without a license.
Mm-hmm. Mm-hmm. We've known that she's been operating. I've been working on this for 2 years with the attorney trying to get Airbnbs out of here, and I've known she's been on, her address has been on our list for quite a while.
She did have a special exception that was granted.
By you all?
Yes, for a term of 1 year.
I was unaware of that.
On the 15th of 2024, August 15th of 2024.
Wasn't aware.
And so she's here today for a renewal.
Okay.
And so
Can we protest
for me
renewal?
on a renewal, I'm more interested. It's been a year. I want to know how it operated.
How it operated?
Yeah. There's no code violations on this. There's no. We have no other information than she ran a perfectly fine business.
I can't tell you that. I can't tell you that.
So.
I'm pretty sure she gives her residents pool keys, and we have explicitly in our bylaws saying that that is not allowed.
Okay, so I would need documented evidence that she's running a business out of there that is not in harmony with the existing neighborhood.
So you don't consider an Airbnb, a Vrbo, or short-term rentals businesses run out of your house?
No, I do definitely.
They have to have
think
a
that.
business license,
Yes,
and our covenant says
I'm in
no
agreement
business.
with that, but I'm also instructed I cannot use that in making a determination on a renewal that is established.
Renewal? So what do we need to do?
That would be something between you and your attorneys to take up in most likely district court.
So you
And I'm
hand
not
us...
telling you to do that, I'm just
No,
saying.
that will be our next step. Unfortunately,
Because our purview-
unfortunately, a decision that I feel like you guys could make on this, we will have to pay money and possibly cost her. If she loses, she'll have to pay all that money when it's very clear in our CNRs that there is no business to be run in our neighborhood. We cannot list every single one in our CNRs and vote on them. It's literally impossible. We would have list after list after list. And every time someone comes up with something new in this country to do in their homes, every community will have to vote on it that has an HOA. And HOAs are set up to protect the residents, not protect people who want to run businesses out of their homes. I'm not against them. If I go to Europe, I stay in one, or I go someplace at a resort. This is a community. There's nothing, it's not a resort. There's nothing for them to do there, except for stay there or party there, which is a big problem. I'll be glad to talk to neighbors and find out if there's been any problems, but I didn't go that far. I didn't know that it was going to go that far as to we had to prove that there were problems when we're trying to prove that there are no businesses in our covenant, and this is a business.
So I'll speak to that just briefly. And first, I want to say thank you for coming to share your concerns. That's not lost on us. You taking the time out of your day to come here and express your issues with the short-term
It's my community, and I love my community, and I've given years to this community.
I completely understand.
Thank you. Thank you very much for recognizing that.
One of the things that I want to highlight, though, and Don began to allude to this, is so we've got some guidelines here as well. And so the decision was made after consulting with our legal that the language does have to expressly prohibit short-term rentals. So I completely understand and get the sentiment that there's no way, and there certainly wasn't any way at the time that the covenants were written to address a phenomenon that hadn't occurred yet, but such is the case with regulation. You write 1,000 pages of regulation on something, and next year you'll find it what needs to be on page 1001. And so I get that, but to address your question earlier, as far as this board is concerned, again, at the advice of our legal counsel, is that for that to be a determining factor, particularly when it comes to whether or not short-term rentals are allowed by HOA covenants, it would have to expressly state that short-term rentals are not allowed.
We have in our bylaws that short-term rentals are not allowed.
The documentation that we've been provided is general language that we see in a lot of HOA covenants and restrictions that restrict business use, a very general term. It would have to specifically state that no short-term rentals are allowed.
In our covenant?
Yes, ma'am.
Okay, so every community that has an HOA in Oklahoma City needs to have that in their covenants?
Yes, all of them are subject to the exact same standard.
Okay.
And
then what do we do? Then
Right.
we can come and then we can tell you no, that we did put it in, and then you'll say no? Or then will we have to then go ahead with the court thing and go all the way with this? Or, I mean, I want to see what my next step is here after we go through a vote.
Those CC&Rs would have to be filed and documented.
Oh,
Okay?
we do. Every change that we make to them, like we
Right,
got.
and I know that today's, I believe it was dated June 1st, 2025.
No.
Well, I mean, that's what it said.
We voted on it November 1st, 2025, the board did, 2024, November 1st, 2024. We started working with our attorney then, after the board voted that we would not allow Airbnbs, that it came under the business thing. And our attorney told us that.
Right,
He said
and
you
I
had
understand,
to-
but I believe, so you had the entire community vote?
No.
Right.
No, the
And
board
so-
did. And the attorney said, in our covenant, it says no businesses, and we have always had the ability to tell them, it's a business, you can't be in here. That's what we were told. Now, we have another attorney for them fighting us on this, so here we are.
Yeah, so we're not in the position to give legal advice and tell you what your next move should be. We can tell you that district court is an available option as far as recourse goes for you, but we can't speculate as to what you would need to do to be successful in your desired outcome. All we can do is review the information that's placed before us, determine whether or not it's in line with the intent of the short-term rental guidelines that we've been given, and then make a determination on that. Specifically.
Okay, so you want to go with short-term, you don't want to go that it's a business, even though you're issuing a business license.
Well, what you're talking about is defining language in a HOA, which again, that's not for us to do. This issue has come up well before today, and it's been the position of the city of Oklahoma City that for that to be a standing that we take, that we say this is not eligible per the HOA, it would have to expressly be written in the documents, in the CCRs, that short-term rentals are prohibited.
When we specify it, and we will, when we specify it and we bring it in front of you, we'll get a no on an issuance?
I'll have to let staff weigh in on that, because I don't believe we've yet
Or
had.
will you say again, we don't want to legally get involved in this?
Well, I don't believe we've had a case challenged yet where the covenants were changed after an existing short-term rental has been granted. So this situation is unique in the sense that she's already been granted a license and a special exception. So as far as this board is concerned, we're only looking at a renewal. We're not, the language would come after that fact, and I can't speak to it unless staff wants to weigh in or legal wants to weigh in on if that changes based on language that's updated after the fact.
So as long as she continued to be a timely renewal, that's what we're focused on.
Okay.
But you can prohibit future applications for short-term rentals, folks that have not.
No, I want to go all the way. I want all of them out.
Well, and it would address all
No
of them.
grandfather or anything like that. We want all of them out. And whatever language it takes, that will be the next thing
We'll
we'll
let
do.
Sarah give us some additional guidance.
Okay. Hi, Sarah.
Hi, hello, Sarah, Sarah Welch, Planning Department. So in this case, in the packet, there are revised HOA covenants specifically addressing short-term rentals. In our copy, they're dated and adopted the 1st of June, 2025. So what I was going to say, though, I was going to read, we had a new or a revised ordinance that regulates home sharing adopted and effective in February of this year. And there was a new section added regarding the board's ability to deny an application based on home sharing. And I just want to read that so that everybody's on the same page. When evaluated an application for home sharing or short-term rental, special exception, the Board of Adjustment may consider as a basis for denial any restrictive covenant which both, one, specifically identifies home sharing and short-term rental, as that term is defined in our code, as a prohibited use of the real property on which the use would occur, and two, is filed of record against the real property on which the use would occur. That's something that staff would not be able to confirm. Okay. Then it goes on to say, provided this subsection shall not prevent the timely renewal of any home sharing or short-term rental special exception that was lawfully issued to the operator of the home sharing short-term rental accommodation prior to the effective date of this ordinance. So the effective date of the ordinance when this was adopted is the 16th of February, 2025.
May I say something? What are you reading from, June 1st?
Sure.
Tell me again what that is.
Oh, in our packet, I'm reading from the protest that was submitted from your HOA.
Yes, and she gave you all a packet that we sent out on rules and regulations for our community because of maintenance issues. It was all the rules and regulations for our community, and she used that we were saying that's when we decided there was no Airbnb. Because I watched the video. That's why I'm here today. I watched the video of the last one that you gave her the license. She had been over a year with no license, and you gave her license, and she used that, and we had sent in the same papers we sent in this time, but they weren't considered, evidently. I never saw anybody consider them. But the rules and regulations that were just sent to every homeowner for, hey, by the way, you need to replace the siding on your homes because we're getting ready to paint. This is your responsibility. That's your responsibility.
What we received in the packet was a protest by Larry Harris. And
from what? It wasn't from us.
From Larry Harris.
Section 8.1, right here.
So this is what it appears to say. I can't do it. But whether it applies.
So when did you get this? This is the one he sent in last time. Where was the June 1st rules and regulations that you mentioned? That wasn't this that we adopted. It was short-term rentals.
Right. But this is.
I don't really understand what this is here. What you're saying is, that was our vote on how long a short-term rental was. Right here, section 2, that was a vote on that. We weren't voting, that's already.
Is it your position that you all have filed CCRs of record that expressly prohibit short-term rentals? Or are you saying that you guys made
They do
a
not, those are bylaws.
Yeah, so what
We were
you're-
unaware that we had to put all this stuff in our CNRs. You know, it's very expensive to have as I explained, it's very expensive and time-consuming to have a vote within a neighborhood if you're familiar with HOAs.
Yeah.
So we were trying to go this route first, and
Yeah.
we were told that we wouldn't go anywhere, but hey, I wanted to come and try.
No, and again, like I said, I'm appreciative of you taking the time to come here. We want to share any information we can with you, but for what you're trying to accomplish, it would need to be recorded CCNRs.
Okay.
Expressly
Okay.
prohibiting them.
Sure. You'll see us again.
Yep. And again, I want to go back to what I said earlier. I think for me, it's very important to know how the business was operating and if there was any reason why we shouldn't do a renewal. And,
You know,
and that would take.
It just sets a precedent, Don, Mr. Noble. It just sets a precedent, like the Airbnb that's across the street from me. I can't get back those weekends that I've been sleepless. Oh, just call, the owner says, oh, just call the cops. Okay, what am I going to say? He's running an SUV for 6 hours out in the parking lot, smoking pot, not the parking lot, in the driveway, for 6 hours. There's kids running with beer cans and riding each other's backs up and down the street. We can't get those days and nights back. So if she has
For me,
a run
the only way you're going to get that stopped is to document that, have photographic evidence, video
listen,
evidence. You
I
bring it to us
documented-
and we can stop it.
I tell it to Airbnb, they get warnings, you know, it's really a tedious process for all of us, and it's just not fun living by an Airbnb. Can they be nice? Yeah, a lot of them can be nice, but then I'm supposed to police the neighborhood and decide who's nice and who's not, and then I've got to fight the ones that aren't nice. You know, I do understand your position. I don't recall anything from Caitlin. Maybe my secretary does, but anyway, like I said, thank you for your time.
Thank you.
Thank you. Got one more sign.
To be honest, our attorney told us we wouldn't win, but like I said, it was worth a try. Thank you. Thank you for your volunteering to do this too. I found out that you're all volunteers, and being a volunteer, I understand what you're going through.
Okay. Caitlin, hang on just a second. I got one more signed up. Nick Henson.
I'm sorry.
I was calling on Nick.
My name is Nick Henson. I represent Caitlin. I'm with Henson Legal PLLC out of Norman. My number is 32010 for the record. I wanted to address something. I believe brevity would probably be the word of the day right now. I believe the HOA representative is conflating two issues. I think esteemed member Noble addressed it. We have a civil component here and we have a licensing component here. That which is before the board today is a renewal. The property is zoned correctly, meets all city licensing requirements, no material violations, nuisance complaints, or safety issues are of record, and all applicable fees and taxes are current. There's nothing of record that shows that my client's operation of this Airbnb, short-term rental, whichever you like to call it, is in violation of anything which would give the board reason not to do this renewal. There is one thing I do want to address, which I think is important here for the board. There is a civil component here. I'd like to briefly address that. First, there is no formal amendment, I know you addressed this, to the covenants. I have addressed this matter with not only the HOA, by sending them correspondence in response to their request to my client to cease operations, but also to their counsel of record, which is Matthew Winton with Winton Law. That should be of the record. I have addressed this with them multiple times. I would anticipate that the memorandum that you received from the city attorney has addressed the Graham v. Reynolds, the Crystal Lakes HOA v. Just Like Homes, the Silverhawk HOA. There is substantial case law in Oklahoma now addressing short-term rentals. It's very clear, it's very concise. I think you spoke to it eloquently when you stated that unless there is specific language in the covenants, in other words, if there's ambiguity as to whether or not this should be restricted as a use within the HOA, then again, it goes to a civil matter. There are a certain number of things, a certain level that they would have to achieve before the court, not this board, to address this matter. The Counsel for the HOA was the counsel in the Civil Hawk matter, which was overturned by the appellate court on, and I do not say this lightly when I speak to this, the covenants, the language, the situation, everything was almost identical to these covenants. It almost looks like, and this happens many times, I do real estate law for a living, where covenants are boilerplated. The attorneys take them, they copy them off, they're one by one. These are almost identical. The section she speaks to, 8.1, in my response to the HOA and response to their counsel, is identical. Civil Hawk was overturned for the exact reasons you spoke of, the ambiguity in the covenants. This is not a matter for this board of directors. I've been trying to address this with this HOA for a very long time, amicably and with their counsel. If they have a matter that needs to be addressed in regards to the covenants, in regards to violations of the covenants, of what they believe is a business interest, there's a building right over there where this can be addressed. As far as the business licensing is concerned, my client has met every requirement for renewal. She's been doing this licensed. I would like to make sure that is clear. She's not been doing this without a license. And there's been no complaints. In fact, if anything, it's been more than peaceful. And I can see no reason why this shouldn't be renewed. Thank you for your time. Any questions? No. Thank you.
Okay.
Can I clear a couple of things up for the record?
Go ahead.
I believe that the HOA lady has me mixed up with another HOA or a short-term rental in the neighborhood. I am familiar with that person. I know that they were operating without a license. So I believe she has me mixed up with that person. So I've had my license for a year, as you guys know. As far as the stories that she told about people in the neighborhood, I've not heard that. My neighbors, I have all my contact information from my neighbors all around me. I've asked them, please keep an eye out. Please let me know if there's bad actors. I don't want them in my home, so I do try and keep an open line of communication with all of them to ensure that I have respectful residents within my short-term rental. There was one other thing I was going to add. And I know it doesn't really, like, to his point, there's a whole nother case for this, but I did actually reach out to this HOA prior to even buying in the neighborhood and ask if there was anything in their covenants that prevented a short-term rental. And I received a response of no, there's nothing at this time. I would not have proceeded with purchasing in this neighborhood if they would have just told me yes at that time.
Okay. Nobody else signed up. Is there anyone else who wants to address the board on this application? Go ahead.
I was wanting to see if I could go ahead and proceed with a 3-year.
Okay, yeah, let's go over right. Let's go over the application a little bit. You had a maximum of, you have 3-bedroom, 2-bath home, maximum of 7 guests. Quiet hours on your application, 9 p.m. to 8 a.m. Maximum number of vehicles, 2 in the drive, 2 in the garage.
I typically do 1 in the drive, 2 in the drive, 1 in the garage, just because of the weird curve.
Okay. And then the term would be 3 years.
Okay. Thank you.
Anything else?
I think we're ready for a motion then.
Okay. I will make a motion to approve case number 16063 on the basis that it meets the statutory requirement for a special exception.
Was it 3 years already listed in the application?
With 3-year term.
Second.
Okay, motion and a second. Cast your votes.
7.
You're approved.
Thank you.
Item number 9, case number 16058 is an appeal by Greg Kennedy of Hartlaw, Conger and Kaysen on behalf of Clay Hayden Riggs from the decision of a decision of the city official regarding the issuance of a fence permit and provisions governing the setback of a structure on a corner lot side of the property in the R1 district located at 4001 Northwest 44th Street.
Okay. Go ahead, Mark.
Good afternoon. I'm the attorney for the applicants in this case, Clay and Hannah Riggs, who are here with me today. This is an appeal of a final decision of the Oklahoma City Development Center regarding its interpretation of the municipal code provisions governing setback of structures on corner side lots. Mr. and Mrs. Riggs live at 4505 Lombardi Lane, which is in the Bush Hills Addition in Oklahoma City. Address, zip code, excuse me, is 73112. Their house fronts Lombardi. Lombardi runs north and south. Their neighbors to the south, who are the opponents in this matter, Mr. and Mrs. Garcia, have a house that fronts 44th Street. Their address is 4001 Northwest 44th Street. And so the Garcia's lot is a corner lot. It abuts both 44th Street and Lombardi. And their house, since it faces 44th, they treat the part that abuts Lombardi as a kind of a side yard. The dispute concerns an 8-foot stockade fence that they erected, and the rear portion of that fence runs east and west and is parallel to my client's driveway. It extends out to the east and then turns south and runs parallel to Lombardi, and then turns back to the west and connects up with the side of the Garcia's house. There's no dispute in this case that there's a 60-foot right-of-way on Lombardi, 30 feet from the center line each way. There's also no dispute that the portion of the fence running along Lombardi is currently within the right-of-way. It was constructed about 5 feet in the right-of-way. I don't think there's any dispute about that. It's about 25 feet from the center line of Lombardi. So the fence, and I believe they've acknowledged that they need to move the fence to get it out of the right-of-way, so it's going to be moved one way or the other. The question for us today in our position is that because it is a corner lot side yard fence, it's required to be set back an additional 15 feet from the right-of-way line. And we've set forth our authorities for that. Most of it comes from Chapter 59, Section 2150, which is the definitions section of the code. And there are several definitions, at least several that are important. A corner lot is a lot abutting upon 2 or more streets at their intersection. We clearly have that here. A structure is expressly defined to include fences. It says, I'm reading part of the definition, but it says this includes but is not limited to main and accessory buildings, advertising signs, billboards, poster panels, fences, walls, driveways, sidewalks, and parking areas. And then, most importantly, there's a specific definition for corner side yards. There's a definition for front yard, there's a definition for rear yard, there's a definition for side yard, but there's also a separate definition for corner side yard. And if you look at, and there's also a figure, I'm looking at figure 2000.7, which distinguishes between corner side yards and interior side yards. And then we also cited to Chapter 59, Section 6100.2, which is a table that shows setbacks in the R1 district. And again, the setback, it shows the front yard setback, the rear yard setback, but then when it comes to side yards, there's an interior side yard setback of 5 feet and a corner side yard setback of 15 feet. So the code draws a distinction between those two things. The City Development Center, basically, after the fence got put up, we engaged, started speaking with the city officials. Eventually, I spoke with Stephen Barker, and the city's position, ultimately, after we submitted a bunch of information to them, was that their position was that a fence in this context is not really considered a structure, and they based that on a historical interpretation because so many people have their rear yard fences within the setback. And so that's kind of their basis. I asked Mr. Wise to confirm whether that was the Development Center's final position. He said, yes, it is. And so we made this appeal. And ultimately, our position is that based on the definitions that I just read, and also I think it's important to consider why there's a distinction in these definitions. And we think that it's obvious that a corner lot side yard issue is important because of visibility. And that's what my clients are concerned about in this case. When they pull out of their driveway, you know, they're looking at an 8-foot tall fence, and they have to kind of peer around the corner as they come out, and they're concerned about the visibility of traffic moving from south to north on Lombardi. So we think there's a reason for those differences in definitions. We don't think that the City Development Center's position is really applicable in this context, because they were talking about rear yard setbacks, and this is a corner side yard setback. And we think that that safety issue is important, and that's the reason for the 15-foot setback. And we would request the board to make a determination that the side yard setback of 15 feet is enforceable, and that the fence should be moved to the west to 15 feet from the right-of-way, which would be 45 feet from the center line of Lombardi.
Questions or comments?
Any questions?
So your main concern, I heard you say, was the safety issue?
Yeah, I mean, it's a tall fence that runs, my client's driveway runs right next to it.
Yeah, I was there this morning. So.
Oh, you looked at it, okay,
Yep.
yeah. We think that, and it also affects just a long-term view of what they had. You know, obviously they could see all the way down the street previously, and now they're just kind of walled off from it.
Paul, you're up.
Paul Lefevre, 522 Colcord Drive. I represent the Garcias, who are here with us today and available to answer questions. This is really a straightforward matter. It's not complicated. The city issued a fence permit on February 24th of this year. An appeal was filed 163 days later from the date of decision being when the fence permit was issued. This appeal is out of time. Now, regardless, let's dismiss the issue of the encroachment into the right-of-way. My client have already, in our written statement and to the attorney for the Riggs, we've stated that we have concluded that the fence is roughly 5 feet in the right-of-way, and it will be removed back to the right-of-way property line, and that will be done in due course when this process is over. It was just a mutual mistake in discussions with staff. I don't believe it's anyone's fault. It just worked out that way. So that's being handled and has already been agreed to. The appeal here has to do with the additional 15-foot setback to the, because this is a corner side yard. All the discussion so far has involved Chapter 59, the zoning code. And factually, everything that's been stated is generally correct. However, what's not been presented is that Chapter 19 of the municipal code has to do specifically with fences. It recognizes a fence as a structure, and as a structure it has to follow the zoning code, except, and this is written into the code, 1922, that rear yard and side yard fences are accepted. And that makes sense in that you don't want a backyard fence X number of feet off of the backyard utility easement. Similarly, I think if it's just understood, if you go around Oklahoma City, fences are required to be out of the right-of-way line, but they're not set back an additional 15 feet. And so I think staff's understanding of the code is intuitively correct, and this is the way they've done it for decades here, 100 years, but the precise reason why is what it says in Chapter 19, that the fences are accepted. Happy to answer any questions if you wish.
I think I'd like to have an answer to the timeliness of the appeal. And I think that's probably from either staff or legal.
Do we have a date of the appeal?
Yeah, it was August 7th. August 7th.
August 7th.
Yeah.
Yeah, come on back up, Mark, and let's wait for staff to answer that question first.
Excuse me?
I just want an answer.
Okay. Well, so we wouldn't get notice of a fence permit. We didn't, I mean, I didn't even get involved until long after he got a fence permit. What triggered everything is when he put the fence up and we saw where it was. And until then, we didn't know exactly where he was going to put the fence.
Okay.
So as soon as that happened, I engaged immediately with the city and said, are you going to allow the fence to be there? We think it's in the right of way. And they kind of went back and forth and back and forth. And finally, I got an email from Stephen Barker who said, he gave me this interpretation, and that was on July the 8th in an email, and I've got the email, it's in the packet. And so then I thereafter asked Mr. Wise and copied Stephen Barker, will you confirm that this is the city's final position on this issue? And he did. And so we actually filed our application on the 6th of August, but I think we left out a couple of, or they asked for word versions or something on the 7th, and we submitted that on the 7th, so.
Okay. And your interpretation then was like August 4th when you got that final email from Scott Wise that determined that was what was to be.
Out of an abundance of caution, I wanted to comply with the 30 days from July 8th is what, I mean, but
Okay.
yeah, I mean, I think I could argue that it was actually August 4th.
Okay.
And then I would like to, if you're finished, I'd like to say one thing about that section that he referred to. The section, that's Chapter 19, and the section on fences. First of all, I would note that it's an older provision. It's a 1987 type provision where the definitional section that I was referring to in the actual zoning definitions is newer. And I know sometimes things like definitions, older definitions in other sections don't get caught up. But either way, regardless of that issue, the point I was making, trying to make, was that this talks about side yards and rear yards. And what we have here is not a side yard. There's a specific difference between a side yard and a corner lot side yard. There's two different definitions. They're referred to separately throughout Chapter 59, Section 2150. And so, and I think there's a reason for that. And as I said, it's a visibility issue. An interior side yard, it's not a big a deal, but when you're doing it on a corner lot and you're putting up a side yard, it's like a front yard. There's two frontages. And so I think that's why, there's a separate definition for that in the code and that a separate setback for it. It's different than the interior.
Okay. Scott, if you could come up and explain to me why the decision was made the way it was.
Okay. Scott Wise, Development Center, Oklahoma City. Sorry, I'm a little bit unprepared. I was running between meetings here. So the decision on this was based on our determination for that, corner side yard, the setback requirements. I don't have it yet pulled up in front of me, but it's always been our interpretation that this scenario would be allowed. We've had this in multiple situations in the past, and I wish I could get that pulled up in front of me, but I don't have it available, so I can't. Do you have it? The definitions? Yeah. Yeah, that'll work. Sorry about that. Again, sorry for the delay here. Okay. So like I said, our determination based on this is going to be from the definition of the yard, side yard, setback, and open area, which extends beyond the required front yard and the required rear yard, and has minimum width measured from the side lot line as specified for the zoning district in which this is located. Steps may extend into the side yard, et cetera, et cetera, et cetera. So it's fairly, broad in that sense. But that is how we've always interpreted it. It is not a front yard, it is not a rear yard, it is a side yard, even though it may be, of course, corner lot, but it is still a side yard. Now, there are limitations and restrictions in our municipal code for site triangles, violations of the site triangle, whether it be on a street or a driveway, and those are separate requirements found elsewhere in the code I could pull up. But in this case, like I said, our interpretation and definition of a side yard has always included this corner side yard aspect.
Anything else? Paul, you want to go ahead again? Mark, you want?
Okay. First of all, there is no site triangle issue here. And staff has not raised it. I've drafted all these calls out. There is no site triangle issue. So that's a straw man argument. If you'll think about it, if the gentleman's argument is correct about this distinction between a side yard and a corner side yard in 59 somehow trumps what it says in Chapter 19. Think about a street. If a house is not on the corner, it has a side yard, but there's no rights-of-way on those side yards. The only rights-of-way exist on the corners. And just because Chapter 19 may have been written and approved sometime before the provisions in Chapter 59, that doesn't void them out or doesn't mean 59 trumps them. It's just, I think the definitions are being stretched out of whack here, and that's not how things have been done, and certainly not what the code requires. Anything else?
Yeah.
I would just say that if that's true, then the table that shows a different setback for a corner side lot from a regular side lot, and the definition, the separate definition of a corner side lot and the separate definition of a side lot, it renders all this language superfluous or meaningless. It should be considered, and I think what they're asking is for it to just be disregarded.
Well, I think more they're asking it for the fence itself to be an exception, not a shed or an outbuilding.
Yeah, understood. I mean, but it's...
And I'm going to tell you, I drove the whole neighborhood just to see what other fences, side yard fences, what this looked like in the practical sense of what this would look like to be put back onto the right-of-way line, and what it would look like for the applicants backing out of their driveway. I actually pulled into their driveway and backed out. And so for me, in the applicable sense for this case, to move the fence, to move it back onto the right-of-way line would be in the same effect as other fences within this neighborhood. It doesn't look out of place. And I think that is a lot of the reason why they don't consider the fence a permanent structure. If they needed to get through there, the owner of that fence would have to move that fence.
Well, I think I've made my argument, but I know that my clients would disagree with it looking in harmony with everything else in the neighborhood, but they're acutely affected by it because they're right next to it, and that's just, the way it is. But I just find it hard to ignore these specific definitions in the code, and so that's why we're here today, is because we had those. And
yep. No, and I agree. I mean, and then they want to exempt the fence on the one side. So.
Yeah. So my thoughts on it are, Section 19. The 22. I think that maybe some of the answer to the mystery, so to speak, in that it leaves out the corner lot side yard setback you alluded to earlier in regards to just the difference in time and when the ordinance was accepted. I also agree that the amount of time that has elapsed since an ordinance has been adopted in no way affects the validity of that ordinance. I think that for me it's pretty simple. I think it states it lists rear yards and side yards because that's typically where you see fences. It doesn't list front yards here. We don't typically put up fences around the front yard. So I think had corner lot side yards been a part of the nomenclature of the planning staff at that time, I'm convinced that you would see it here also. But none of that is my reason for not supporting the appeal. I want to go back to something that Mr. Lefevre said earlier. In regards to the timeliness of the appeal. I don't share the idea that the appeal was filed timely. We've had similar cases like this come before this body before, and we've taken the position that the time that the permit was issued is the time that the clock starts, and the basis or the rationale for that understanding is simply based on the fact that those permits are made publicly available. So as far as I'm concerned, those serve as constructive notice. If we allow an email, and again, not taking away from the due diligence of you trying to get to the bottom of staff's reason for making the decision, but if we begin to allow the clock to be reset anytime somebody reaches out to a member of staff for clarification of something, there would never be a time when there would be a bona fide answer, because a different neighbor could come back later and say, well, I wasn't a part of that, because your email to Mr. Wise is much less public than the issuance of a permit that any member of the community can get on and see. I don't have access to your email. I don't have access to Mr. Wise's email. So if I too am a neighbor in that community who's also aggrieved by the fence placement, I don't know about it until I find out about it. And if I've been on vacation, I come back and maybe a month later, I'm filing an appeal as well. So it's for that reason that I don't support this appeal, simply because I don't feel like it was a timely appeal.
The only thing I would say, and maybe you don't want my response, but the only thing I would say in response to that is that the permit that was granted didn't give him the right to put the fence where he put it. And so it's not even.
Say that one more time.
The permit that was granted to him didn't give him the right to put the fence in the right of way.
You are absolutely correct, and I considered that as well, but the permit gave him the right to place the fence outside of that right-of-way, up against that right-of-way. Him putting it in correctly does not void what he was granted permission to do. So had staff issued it erroneously and said, you can place this fence here within this right-of-way, he did it, and staff came back and said, oops, we made a mistake. We'll give you a new permit, and you can now place it further inside of outside of that right-of-way, then you would be absolutely correct, because that decision was now being made at the time that they addressed it. But staff didn't make a mistake in the issuing of the permit.
Okay. Anything else from the board? Paul, anything else? Okay. Are we ready for a motion then?
I will make a motion. I will make a motion to deny case number 16058.
Second.
Okay, motion and a second to deny the appeal. Now cast your votes. Sorry. Wrong screen. Okay. Appeals denied. Looks like the next three were continued.
Item number 10, 11, and 12 were both continued, so they're at the end of our docket.
I don't have any additional items. No board committees. Does anybody want to say anything? Rita? Nope. Citizens to be heard? No other business? I'm adjourned.